Hi guys, ready to learn a new case law? So, this case law is based on doctrine of constructive notice. What is doctrine of constructive notice? Do you know? Good. And those who don't know, let me help you. In my previous video, I have already told you about the AOA and MOA of the company. So if you don't know about them, then watch video given in the description first. Okay, now after the company is registered with the Registrar of Companies, the office of the Registrar is a public office and consequently the memorandum and articles become public documents and then they can be inspected by anyone on payment of a nominal fee. Hence, it is presumed that every person dealing with the company has read these documents and understood them before entering a contract with the company. In simple language, whether you have read these documents or not, it will be taken as not only you have read those documents but also understood it. So I think we should also see the articles of the company as doctrine can apply to us also. The company's article of association says all deeds, hundais, checks, certificates and other instruments shall be signed by the managing director, the secretary, the working director on behalf of company and shall be considered valid.
Hello ma'am, please sit.
Yes, sure.
Madam, I got to know that you are interested in buying bonds of our company.
Yes. Indeed.
Okay, I have already made the papers, and me as a secretary and the working director have already signed the mortgage deed of bonds of rupees 1,000.
You have the authority to execute this bond?
Yes ma'am, don't worry.
Okay, then I will take this mortgage deed.
Great.
Sir, I have taken a mortgage bond deed with this company of rupees 1,000 and now they are denying this fact and trying to make this bond void. I have the necessary papers also. I want you to enforce my deed.
Sir, but it is ultraviewing our articles as the bond has to be signed by secretary, working director and the managing director in order to make it valid. But this bond is signed only by two persons and the managing director has not signed, thus it is itself void.
Sir, debt are regularly contracted in accordance with the powers and authority possessed by the said director and secretary under the articles of the said company and the special resolutions passed from time to time. So we can pre-assume that all the necessary steps has been taken before.
If the mortgagee had so informed herself, she would have discovered that a deed such as she took requires execution by the three specified officers of the company. And she would have refrained from advancing her money upon a bond executed as is the suit bond. In place of the vague recital of authority which the mortgage bond contains, reference would properly have been made to the article empowering the signatories to act in this respect. Notwithstanding therefore that the mortgagee may have acted in good faith and that her money may have been applied to the purposes of the company, bond is nevertheless invalid, and that the plaintiff cannot recover upon it.
I know, you may be thinking that it is not fair. This rule is very harsh, but we'll also have some relief. For it, I will tell you in my next video. Till then, be aware and read the documents of the company before contracting with it.